welcome in. We're here for another episode of SSD Mythbusters. I'm Jeremy Worley. I am your host here with Josh Worley, who's our expert SSD attorney, answering all of our questions, helping us find out what's truth, what's fiction, what do we need to know, one topic at a time. That's what we do here. We take a myth each episode, and Josh helps us kind of get to the bottom of it. So Josh, welcome.
Thank you.
All right, so today we're going to be talking about age-related questions and applying. And this is an interesting question because whether someone is a young worker is kind of a scale. For some, they might be young at heart. I gave my wife a birthday card this week and it said, "Happy birthday, you were still young." And it said ish. So we're not going to clarify who's young. Maybe you can help us know who's young or young-ish.
Yes.
We're probably closer to the ish category. But so the myth today is young workers can't qualify for benefits. Okay, help us understand, how does the age apply and how is it relevant for purposes of applications?
Sure. Well, I'll start off by saying that is a myth. That is false. That someone that is young cannot qualify. That's not true. The truth is that you can qualify for Social Security disability even if you're young. Okay, even if you were in your 20s or 30s. The reality that is that the younger you are, the stronger the case you need to have. Okay, so if someone was 60 years old and they had certain limitations and certain medical issues, and they were compared with someone that was 20 or 30 years old, then it's way more likely that the 60-year-old is going to get approved as opposed to the 20 or 30-year-old. And the reason that's the case is because Social Security will take into consideration age, education, and work experience when they're considering whether someone's disabled or not. So the individual that is 20 or 30 years old, Social Security looks at them and they say, okay, they're younger, they have the ability to maybe learn a different career, learn a new skill set. They just have more of an ability to be able to figure out full-time work as opposed to someone that's 60 and really is not at a point in their life where they can go learning something different or figure out a job. So the 20 or 30-year-old just needs to have really strong medical documentation of whatever their health issue is, whatever their disability is, and needs to make sure that they've just been to the doctor, that they've been to specialists, that they've got objective information, objective tests, MRIs, things that prove without a shadow of a doubt that they've got functional limitations that impact their life in a big way. So the younger you are, the stronger the information and the evidence you need to prove your case.
Okay, I think that's pretty straightforward. Younger is not a total bar, but younger does make it a higher bar you got to clear, because if the standard is you got to, you may be able to work. The younger you are, you have the potentially the ability to do even more things when you're younger. So as you get older, that's a little bit more difficult. So it's a sliding scale. So I think that answers it for us, Josh. Thanks for clearing it up. If you're younger, you're going to have more evidence. All right, hopefully this has been helpful for you. We're going to keep doing these episodes, providing all the information you need. You can reach us at idlawcenter.com. We are the Injury and Disability Law Center. Josh has a nationwide practice and he helps people all over the country. So if you have questions like this one, like if you maybe think you are young-ish and want to apply, Josh can help give you some counsel on that and maybe even represent you. So thanks for joining us. We're going to do it again next time.